Will there be one argument or just two arguments on this? It'll be two. Have you already divided your time?
We'd like to propose 10 minutes and 5 minutes.
Okay, thank you very much. Yes, sir. If you're ready, you can proceed. You'll need to also let us know if you want any time for rebuttal.
Yes, Your Honor.
Okay.
My name is Dale Cantrell from the Anderson County Bar, and if I could request a 2-minute rebuttal time.
Okay, then. Sure thing.
This case has a very complicated and long factual history in that it was actually two cases that were about 6 years apart that came from the same court but two different judges that were converged. The key facts all occur in the first case, which was filed in 2014 by Mr. and Mrs. Phillips against Mr. and Mrs. Hackworth, who were their parents and in-laws, respectively. Mr. Phillips was the son-in-law of the Hackworths, and Mrs. Phillips was their daughter. Mm-hmm. The property in question involved an 1,100-acre piece of property with a private lake in Putnam County that had been permitted as an aggregate or a sand mining site that had approximately $200 million worth of aggregate on the property. Mr. and Mrs. Phillips were third-party beneficiaries of a partnership agreement and had also, when, I don't want to say the real estate market had taken a plunge, but when there was financial difficulties in the United States between 2008 and 2010, Mr. and Mrs. Phillips began loaning money to their father and mother-in-law in order to help make payments on the bill until the highway industry could come back. The aggregates were used almost exclusively to produce asphalt, which are used on roads, and we went through a period of time in the state where we weren't building roads. So the case, Mr. and Mrs. Phillips were originally represented by Daniel Forster, who's now the chancellor for the 7th Judicial District, was essentially a debt collection case and for determination of what money they were owed should the property be sold, and it was actively being marketed for sale at this time. The lawsuit was filed in May of 2014. Sometime around July, and Mr. Ray Lacey, who is a local attorney, had contacted Chancellor Forster, said his firm would be entering an appearance, and this is where everything occurs that I think gives rise to the case. No action was taken as far as filing an answer, responding to any interrogatories, request for production of documents from the summer of 2014 until January of 2015. So legally, the case is just sitting there. Behind the scenes, Mr. Lacey and his law partner, Mr. Price, had met with two of the other appellants, David Everhart and his wife, who is known as Franda or Dusty Webb, and they realized that this property, which had an indebtedness primarily through Clayton's Bank and some back taxes of about $2.4 million, was a substantial asset. And they formed a company called National Aggregates LLC on September the 1st of 2014. They did something that I feel was highly inappropriate in that they formed National Aggregates, and Ms. Webb held the Hackworth interest in trust. So even though Mr. Hackworth and Ms. Hackworth were 100% owners of the property and the indebtedness, they formed the LLC, which was a shell corporation. They transferred the entirety of the asset in there for a fake promissory note of $6.8 million just to get the property out of the Hackworth name and into the name of the LLC. Immediately, the appellant Price contacted Clayton's Bank and said that there were two fake members of the LLC that do not exist. Capital Sand and Mountain Tist were the two LLC members in order to get Clayton's Bank to stop foreclosure efforts on the sand. Then throughout the fall of 2014, Price and Lacey are negotiating with a trust lending, which is a bridge funding company, to get $4.3 million as a bridge loan because they had a $16+ million loan from Lenders Capital that was going to go to the LLC. None of this was disclosed to Mr. and Mrs. Phillips or Chancellor Forster, who basically are just waiting in time. Chancellor Forster had filed a lien les pendens on the property in probably November of 2014 because he was worried about a pending foreclosure from Clayton's and wanted to make sure he had his note protected. In January, Chancellor Forster finally got tired of waiting and filed a motion for default and a motion to compel discovery, at which time an answer was filed and the answer to the discovery was filed. They did not disclose that the LLC now had 7 members, a Gary Hibben, a Tom Badgett, Mr. Everhart, Mrs. Everhart, Ray Lacey, Gary Hibben, and Jim Price. So none of that was disclosed to Chancellor Forster. They did not disclose that there were ongoing negotiations with 2 lending institutions. None of that was disclosed. So ultimately, when that was provided, a deal was proffered to the court that says, look, we will pay you $350,000 at 4% per annum with first payment not coming due for 3 years. That the property has sold for $6.8 million, and the Phillipses accepted this. This is their family. They said, sure. Almost immediately after that order went down in February, the National Aggregates people filed a fake bankruptcy petition. They said that one of the LLC members, Gary Hibben, and he testified in deposition that he was not aware of this, that he did not approve this, that he did not have the funding to buy it, but they filed a bankruptcy petition to stop another foreclosure by Clayton's, saying that Mr. Hibben had purchased the property. That bankruptcy petition lasted about 60 to 90 days because there was no support to it. So it was voluntarily withdrawn, and then they sold the property for just the amount of the Clayton's indebtedness and the IRS tax indebtedness of $2.4 million total. The property, the LLC and Mr. Price had appraised in the fall of 2014 for $10 million just as raw land, not taking into account the aggregate. They sold it for just the amount of the payoff of the Clayton's note and the amount of the tax payoff with a 3-year buyback provision. It's my belief they did that intentionally because they still anticipated getting the $16 million from Bankers Capital, and they, in fairness to them, they kept getting letters from Bankers Capital that would say, within 30 days, we're going to loan you this $16 million. Flash forward in time, 5 years goes by, nothing has been done to pay Mr. and Mrs. Phillips. They then begin a investigation on their own where they reach out to Tom Badgett, who was listed on the Secretary of State's website as being National Aggregates contact person. Mr. Badgett and Mr. Phillips met at Mr. Phillips's house. They recorded each other's meeting. Mr. Badgett said, I've never heard of you. Me and Mr. Hibben did not know you existed. We did not know you had a lien. We did not know anything about this agreed order. We're just members of this LLC trying to get it out. And it's important to note, Mr. Hibbens was active in the construction industry for road construction. Was his value to National Aggregates is they would stripe the interstates and the roads. Mr. Badgett had significant entrepreneurial experience. The other members of the LLC who knew about the Phillips lawsuit had no real aggregate experience or business experience to do this loan. So a second lawsuit was started, which essentially said National Aggregates and its members committed fraud against the Phillips and against Chancellor Forster by not disclosing the information that was going on behind the scene, not disclosing that this was an improper transfer, and basically defrauded them out of their $350,000. The court, everybody started cross-suing and diverging. Hibben and Badgett, during their testimony, disavowed any knowledge of knowing the Phillips, and they said that Raymond Lacey, Jim Price were active members of the LLC. Mr. Price and Mr. Lacey said, no, it was our law firm that held a membership. We weren't individual members. They denied, Mr. Hibben denied that he was ever consulted about purchasing the property in order to go into the bankruptcy. So the facts all just went, I don't want to say haywire, but just everybody started pointing the finger at everyone else. And the chancellor, or not chancellor, Judge McAfee, who was sitting in interchange for Judge Elledge on the second cage, granted a 12.026 motion to dismiss for failing to state a claim against National Aggregates and all of the individual members except the two attorneys and their law firm, and he granted a Rule 56 motion dismissing them for failure to state a claim, and he dismissed all of the cross claims that had been filed against the Phillips, and that's why we're here. I do not think that the 12026, which is a very minimum standard for a plaintiff to pass, we just simply have to state, if you look at everything that we've said is true, is there a cause of action? Well, absolutely. I mean, it has to be fraud. It has to be misrepresentation. It has to be deceit. This is a huge record. I think the record alone that we submitted to the Court of Appeals was 7,000 pages. So there
The
are...
October the 17th, 2022 order of
Okay.
dismissal, what does that, what effect does that have on
The which order, Your Honor?
What effect? The October the 17th, the 2022 order, what effect does that have on this case?
Which, can you refresh my recollection as to which order that one was?
Dismiss, well, the order of dismissal, disposing of all the plaintiffs.
That's
We-
the one that they say you should have filed your appeal from.
We had to come back to the court because there was not a final order. When everything was left, they still had an outstanding Rule 11 sanction against myself, Mr. Arnold, and the Phillips that had not been wrapped up. The court thought that it was wrapped up. We went back to the court and said, Your Honor, this is not a final order. We are going to have to clear up the record. And the Court of Appeals said, or not the Court of Appeals, the trial court said yes, and they entered a final order saying, I meant for my previous order to dispose of everything, and then they disposed of the final cross claims that had been made. So I think it has no effect. I think that the brief was filed timely, the order of appeals was filed timely, and as I've been here before, cases we get up here and you all find something that says, hey, this issue wasn't taken care of, you send it back to resolve that issue. This was caught during that time, and we had a hearing that essentially resolved all issues. Any other questions? I've rambled for a while, so I can answer any questions.
I hear none. Thank you.
Thank you, sir.
Yes, ma'am.
May it please the court. My name is Louisa Ponte, and I represent the defendant appellees in this matter. Appellee's argument consists of three main points. The first is that we ask this court to find that it lacks subject matter jurisdiction over this appeal because of that October 17, 2022 order that the court referenced, which was a final judgment under Rule 54.02. The fact is that the appellants failed to timely file a notice of appeal as of right as to both the order dismissing all of their claims and the order awarding attorney's fees. Second, and in the alternative, we ask this court to affirm the trial court's dismissal of this case and the award of attorney's fees. In short, because plaintiffs' appellants have failed to properly plead their case for fraud or intentional misrepresentation. The trial court properly found that the alleged misrepresentation at the heart of this case, that there was no genuine sale of property from Plateau Sand to National Aggregates, was demonstrably true. There were no misrepresentations that were made, and if they were, plaintiffs were not allowed to justifiably rely on them. Third, we ask this court to reconsider the denial of 2 Rule 11 motions for sanctions and to award sanctions for the filing of what we assert is a frivolous appeal. The trial court in this case was sympathetic. It stated that it, quote, did not want to rub salt into the wound of the plaintiff's dismissal, but the fact remains that plaintiff's complaint at the end of the day had no basis in fact or in law. They never conducted a reasonable investigation into their main claim that the sale was not genuine, that there was no proper promissory note, and then they improperly tried to circumvent and delay the final judgment in this action by filing a baseless motion to reconsider, a motion to stay execution of judgment, and now what we term a frivolous appeal. In the meantime, causing needless litigation and unnecessary cost to the appellees. If I may turn to my first point, this court lacks subject matter jurisdiction over this appeal. The court made clear in the 2019 case of Gunn versus Jefferson County that if a party fails to timely file a notice of appeal as of right under Appellate Rule 4A, the appellate court lacks subject matter jurisdiction and the appeal must be dismissed. The facts here show that the trial court entered a final judgment on October 17, 2022. That order properly certified the final judgment under Rule 5402 for two reasons. First, it expressly stated that there was no just reason for delay in the entry of final judgment. And second, the order resolved all of plaintiffs' claims and dismissed or eliminated all 5 of the defendants. The only remaining claims were of the 2 defendants, Defendant Lacey and Defendant Price, who had pending counterclaims. That certification of the final judgment rendered the judgment appealable as of right under Appellate Rule 3A. It gave the appellants 30 days to file a notice of appeal as of right. The fact is they missed the deadline. Instead, they moved for permission to file an interlocutory appeal, but that motion did not toll the 30-day deadline. So when in January of 2023, this court denied them interlocutory review, they were out of luck, and their time to file an appeal as of right had already expired. Next, appellants filed a one-sentence motion to reconsider under Rule 60 in February of 2023. They now argue that that motion to reconsider was in substance a motion to alter or amend, and they claim that that motion to alter or amend should toll the appeal deadline. Their argument fails simply because a reading of Rule 59.04 says that a motion to alter or amend must be filed within 30 days of the trial court's order. Trial court's order was October of 2022. Motion to alter or amend was filed in February, 4 months later. For these reasons, appellees ask this court to dismiss this appeal. When appellants finally did file a notice of appeal as of right, it was to a September 2024 order that was 2 years too late and that didn't address the dismissal of all of their claims. Similarly, appellees argue that this court lacks jurisdiction over the appeal of their awarding attorney's fees for the same reason. The court entered a final judgment under Rule 5402 on April of 2024 without any objection by the appellants, by the way, as to its finality or its reasonableness. They missed the 30-day deadline to file their notice of appeal as of right, and so we assert that this court lacks jurisdiction over the appeal regarding attorney's fees. I'd like to turn to my second point, which is that this court should affirm the trial court's dismissal of plaintiffs' claims. It properly granted the motion to dismiss of 5 of the defendants in this case because, simply put, plaintiff's complaint did not properly allege fraud. In Tennessee, fraud and intentional misrepresentation are different names for the same cause of action. In this case, appellants did argue vaguely that the defendants perpetrated a fraud in a prior litigation to induce them to settle, but it failed to allege any misrepresentations by the 5 defendants who moved to dismiss, none of whom were even parties to the prior litigation or had any contact with the plaintiffs or their counsel. And in fact, appellant's brief does not deny this. The only response that they make in their brief is that perhaps the defendants made misrepresentations during discovery. Even if that's true, which we deny, that has nothing to do with the sufficiency of their complaint. And as this court held in PNC Multifamily Capital, a complaint must set forth the particular misrepresentations, what was said and by whom. Otherwise, it is vague and it does not satisfy the pleading requirements of Rule 9.02. Secondly, the trial court also properly granted summary judgment as to the defendants Lacey and Price for 2 reasons. First, there was no genuine issue of material fact. The alleged material misrepresentation by Mr. Lacey and Mr. Price was that no legitimate sale of property took place. The trial court found that, in fact, it did take place. The sale was evidenced by a promissory note, a closing statement, a recorded quitclaim deed, transfer tax receipts, and the buyer's operating agreement. There was deposition testimony that the buyer, National Aggregates, was formed to operate a mining operation. It was not in response at all to plaintiff's prior litigation. There are letters, there are meeting notes that reference extensive efforts to obtain financing for the buyer to commence mining operations on this property. The fact that no money exchanged hands, which comes up in the appeal brief, doesn't mean that no sale took place. The only problem is that the buyer has had difficulty in obtaining financing needed under its promissory note. So summary judgment was also proper because as a matter of law, plaintiffs could not justifiably rely on the representations of Mr. Lacey and Mr. Price. Mr. Lacey and Mr. Price were opposing counsel in the prior litigation. They never communicated directly with the plaintiffs, and the plaintiffs had a duty to exercise their own independent judgment and rely on the advice of counsel. The Court of Appeals has made clear in the 1996 case of Farley versus Clayton that as a matter of law, one party to a lawsuit represented by counsel cannot justifiably rely on information presented by opposing counsel or adverse parties. Third, we would ask this court to reverse the trial court's denial of 2 of our Rule 11 motions. Our first Rule 11 motion asserts that plaintiffs' claims had no evidentiary support and were brought for an improper purpose. We submit that the factual and procedural history in this case bears that out. At best, plaintiffs' complaint was a fishing expedition. Plaintiffs wanted to find out why it is they were not paid pursuant to the final agreed order in the prior litigation. The bottom line is that payment could be underway under the promissory note as soon as the buyer, National Aggregates, receives the proper financing. Their complaint lacked any basis in fact or law. There were allegations where all plaintiffs' counsel had to do was review publicly available documents that confirmed that the sale took place. They could have reviewed bankruptcy filings that showed that the bankruptcy court approved the sale in this case. And we would submit that at worst, plaintiff's complaint was an attempt at extortion. Under Tennessee law, the use of coercion, even if it's a lawsuit to obtain any advantage, including harming the credit or business reputation of any person, can be considered coercion. And here, the facts show that plaintiffs' counsel knew before they even filed this complaint that National Aggregates was in the process of applying for financing and that they were required to state whether there was any threatened or pending litigation against it. Plaintiffs filed anyway and then asked National Aggregates to pay them $100,000 to go away for a year. National Aggregates refused and as a result lost out on potential funding which would have helped plaintiffs. The trial court should have considered all of these facts to determine, it's a highly intensive fact determination, whether in fact a complaint has a basis in fact or law and whether it was brought for an improper purpose. We submit that the court should reverse and remand so that the trial court may conduct that proper fact-intensive determination. It appears that the trial court had sympathy. Oh, may I just finish this point, Your Honor?
Just complete the point.
Thank you. Trial court had sympathy and didn't want to rub salt into a wound and wanted to shield plaintiffs' counsel from a pending BPR investigation. But we allege that that's not the appropriate legal standard under review of a Rule 11 motion. We finally ask that because this appeal was both untimely and frivolous, that the court award sanctions under TCA 27-1-122. Thank you.
Thank you. Mm-hmm.
Your Honor, may I ask counsel's last name? I didn't get it for our records.
Right.
Aponte, A-P-O-N-T-E.
Thank you.
Mm-hmm. Yes, sir.
May it please the court, Michael Franz here for Ray Lacey, Jim Price, and Lacey Price and Wagner, PC. I want to say first that we agree wholeheartedly with counsel for our co-defendants that this entire appeal needs to be dismissed as untimely. There's no question that the October order that the court's already referenced was certified final. It was properly certified final under Rule 54.02 because it disposed of all the claims asserted by the plaintiffs against all the defendants. There's case law that supports that that is a proper means of certifying a final judgment. It's undisputed that they didn't appeal that within 30 days, and their entire appeal should be dismissed. I also want to point out that while the other defendants in this case were dismissed based on a motion to dismiss for failure to state a claim and for failure to plead fraud with particularity under Rule 9, the parties that I represent, Mr. Lacey, Mr. Price, and Lacey, Price, and Wagner, were dismissed on summary judgment. That's because there was evidence put into the record that showed that the core alleged misrepresentation that the plaintiffs are talking about, the idea that this sale of the property never occurred, that misrepresentation was actually true. And as a result, their claims fail as a matter of law. So the trial court was correct to grant summary judgment for the three parties that I represent. And I want to address, we have an additional issue that only applies to Mr. Lacey, Mr. Price, well, just Mr. Lacey and Mr. Price. They filed counterclaims against the Phillips. The trial court granted summary judgment and dismissed those counterclaims. So we have also appealed to assert that the trial court erred in dismissing those counterclaims, and I want to cover those just briefly. The three counterclaims were for breach of contract, abuse of process, and defamation. I'll start with the breach of contract claim. The basis for that counterclaim was that the release and agreed final order that was entered in the precursor Plateau Sand Hackworth litigation contained a provision that barred the plaintiffs, the Phillips, from ever filing suit against the Hackworths or Plateau Sand or their attorneys at any point in the future. Well, Mr. Lacey and Mr. Price were the Hackworths' attorneys in that case. So by then suing Mr. Lacey and Mr. Price in this case that's on appeal today, the fraud case, they violated the terms of that release. The only argument that the plaintiffs have put forth to argue that that claim should be dismissed as a matter of law is that they say, well, Tennessee law allows us to seek to invalidate a contract like this release agreement based on fraud, and therefore it was proper for us to do that even though the release said we can't sue the Hackworths or their attorneys. The problem with that, though, is that they failed in proving fraud. The trial court dismissed the fraud claim. So the fact that they were theoretically able to invalidate the release based on fraud doesn't matter because they tried and failed. So the release remained valid. They breached the release by filing this lawsuit, and that's a valid breach of contract claim. We think the trial court erred in dismissing that claim. The next counterclaim is abuse of process. This is based on the plaintiff's use of post-judgment subpoena in the underlying Plateau Sand litigation to seek to compel Tom Badgett to provide them information that they were then going to use in their fraud case. That was an abusive process because there was no judgment ever entered. It was improper for them to use post-judgment discovery or a post-judgment subpoena because there was no judgment. And they have argued that there was a judgment because the final order in the Plateau Sand litigation said that Plateau Sand was supposed to pay, they treat that as a judgment. Plateau Sand was supposed to pay them a certain amount of money, but if you look at the actual language in the agreed final order that dismissed that case, all it says is that Plateau Sand was instructed to direct National Aggregates to remit a sum of money to them. That is not a judgment. And so by having a post-judgment subpoena issued, that was improper. The third counterclaim is defamation. That's based on a letter that was sent by plaintiff's counsel to the other members of National Aggregates who became the co-defendants in the fraud case. They've argued that that couldn't be defamatory because it was an offer of settlement under Rule 408. We've cited case law in our brief that very clearly states that that's not the case. The fact that it's a settlement offer and may be admissible in future litigation doesn't mean it can't be actionable as defamation. That argument by plaintiffs is just completely wrong. The fact that the letter came from their counsel is also irrelevant. The letter is actionable as defamation, and the trial court erred by dismissing it. So all the breach of contract, abuse of process, and defamation claims should be reinstated and allowed to proceed. Thank you.
Thank you. Yes, sir.
Your Honor, I want to do a better job of answering the one question that you asked me because I gave you a horrible answer. The October order that you referenced from 2022 does not become a final order, and Rule 5402 is not applicable because of what this gentleman just said. The counter complaint that was filed on October the 14th of 2019 included the 3 counts he referenced: breach of contract, which focused solely on the 2014 complaint's final order and release. The count 2 was abuse of process against the Phillips, alleged by taking the action by having the conversation with Mr. Badgett when it was pro se. And all of those are so intertwined that they involve the same parties, they involve the same process, that Rule 5002 does not make the other part of the claim a final issue, because ultimately Mr. and Mrs. Phillips had to file a motion for summary judgment on those claims. And on March 19th, 2024, they did file a motion for summary judgment as it relates to all of the claims that were in the countercomplaint, which involved the same order, the same parties, and the order granting that motion for summary judgment was entered on September the 30th of 2024, which would make it the final order. And when we went back, it was to clarify that that was, in fact, the final order. So I agree with everything he said. That countercomplaint is the same parties countersuing. It's in the same docket number. Rule 54.02 can't be used to just separate out part of them when other parts are still going on. So I hope that was a better answer to your question. Do you have anything else for me?
I hear none. Thank you very much.
Thank you, sir.
This case now has been submitted to this court for resolution, and we just want to thank the parties for your presentation.